For anybody who doesn't know me, I'm the director of the housing team at Virginia Poverty Law Center. And I do need to point out that we have the real expert. Sorry to be calling you out, Helen, but we have the real expert on fair housing on this call, our immediate past board president and just an amazing fair housing attorney. Helen Hardiman is here somewhere. So I urge you to jump in, Helen, and add all the things that I leave out. But you don't have to if you're having coffee and just chilling. So thank you all for joining. We are taking advantage of the fact that April is Fair Housing Month as well as Affordable Housing Month to have this coffee chat and a series of trainings, actual CLE trainings at the end of the month. There won't be a fair housing training this year. We did that last year during Fair Housing Month, but we do have an assortment of other exciting topics to talk to you about then, so I hope you'll check those out too. But today, this is really meant to be a conversation, not just me talking. So we've got some wonderful slides that Laura put together that we can use to guide our conversation. But I really want to hear from you all what your questions are, your experiences have been, and just other wisdom that you have to share about this. One of the reasons we wanted to do the coffee chat on this is because a number of years ago, I want to say it was about 2 years ago, I was talking to a legislator from Northern Virginia, and the legislator had introduced some bills related to fair housing. And what he said to me, I said, well, why do we need these? We have this great fair housing law, and I'm going to talk in a second about the specifics of that. These things are a little bit confusing. And he said, Christie, nobody knows. Nobody in my district, none of my constituents know what fair housing is. They don't know how to identify or recognize when they may have been subject to a fair housing violation. And so I want to make it more explicit. Well, for I think pretty good reasons. And the General Assembly did not pass his legislation. And I will say, and I know there are people on here who can speak to this probably more eloquently and completely than I, but we think the fair housing law is a really good law. And it's good because it is both specific and yet not prescriptive. And what I mean by that is, if we were to do a training on the fair housing law, you would see that it not only lists all of the ways in which it is illegal to discriminate against someone in housing, but it includes one actual, well, maybe two exceptions, and a whole bunch of other stuff that's really good. So it does not need to be fixed. We do like adding to it occasionally. And when I say we, I of course mean our friends in the legislature in Virginia. And so let's talk a little bit about what fair housing is. I don't know, just a housekeeping measure. I'm not sure who is going to monitor the chat. I will try to do so as I'm talking, but I really, really encourage you to chime in, interrupt me at any time, because this really is meant to be a conversation. So we have both the federal fair housing law and a Virginia fair housing law, and they are designed to give people the right and the opportunity to live where they choose, free from discrimination. And that applies to rental situations as well as purchasing a home. And if we go to the next slide, here we go. So this is a reflection of the Virginia fair housing law. In Virginia, it is illegal to discriminate in the sale or rental or advertisement of housing based on a person's race, color, national origin, familial status, and we'll come back to that, age, being 55 plus, disability, source of funds, and we'll come back to that, military status, gender identity, sex, sexual orientation, or religion. And I just want to shout out the Virginia legislature for adding source of funds, gender identity, sexual orientation, and military status to our fair housing law just over the past couple of years. And thank you. Mary is asking a question about enforcement. I will answer that in a second once I go back to, I think I stuck a pin in familial status and source of funds. Then I can try to answer Mary's question as best I can. But again, Laura or Helen, if you want to jump in and augment my answer, you are always welcome to do that. So familial status is actually about having kids. I remember when I was growing up, we used to go down to Florida every year, and we would go to, my grandmother had an apartment down there, had a condo down there, and there were almost no children. You were not allowed to live there if you had children living with you. Children were not allowed to do certain things at certain times. And this was in the, well, quite frankly, after the federal fair housing law passed, but before it was widely enforced, is my guess, at least in whatever county of Florida that was. So familial status, and this was widespread, and we still see it today. We see or hear of landlords who say, I'm not going to rent to you because you've got young children and that's going to cause too much noise. They're going to cause damage, etc. So it is unlawful in Virginia and across the nation because of the familial status provision of the federal fair housing law to in any way discriminate in housing against someone because they have children. Source of funds, which is not part of the federal fair housing law, but is in our law and was added in 2020, prohibits any type of discrimination against someone who is using what I call a non-traditional source of funds or source of income to pay. And those are often housing choice vouchers or other forms of rental assistance, probably the most common thing that we hear about. But we have also heard folks not wanting to rent with someone if their only income is from Social Security, or if their only income is from spousal support. The interesting, well, yeah, I think statistically, you could probably make an argument that refusing to rent to someone because their only income is spousal support may also be discrimination based on sex. If you look statistically, you'd probably find that a significantly higher portion of people receiving spousal support are female. And we do often see cases where those statistics matter very much. I'm not going to get into the weeds on that today, but suffice it to say, Marty Wegbright, who I don't think is on this call, has this wonderful presentation that he does and that I've been fortunate enough to do with him on how criminal history screenings of rental applicants violates the fair housing law based on statistics. That's just a teaser for something you can get Marty to do. Mary asks, I would love to hear you talk about enforcement of the fair housing law. I understand it's mostly through civil suits brought by the person discriminated against. Who from the county or state can enforce the law, when and how? That's a great question. And in fact, the state fair housing law can be enforced through the Virginia Fair Housing Office and ultimately through a court action filed by the Attorney General. And the federal fair housing law can be enforced through HUD.
I can talk a little bit about that, Christy, if you want.
That would be great. I would love that, Laura. Thank you.
Sure. So there's two ways that somebody can deal with if they have been discriminated against. They can file an administrative complaint, and there's a separate administrative complaint if you're going through HUD and if you're going through the state fair housing office. And you have to file that complaint within 1 year of the discriminatory act. Or you can also file a lawsuit. You could do both. If you file a complaint and then decide, no, I actually do want to file a lawsuit, you can do that. Or once you filed a lawsuit, you can still go back and file a complaint. And you can file a lawsuit in state or federal court, and that has to be within 2 years. So if you're filing a complaint with the federal government, they make it really easy to do, whether you do it like submitting a form online, you can email, you can pick up the phone and call them, send something in the mail. And they try to go through a conciliatory process once they receive a complaint. They'll do an investigation, investigating the complaint, talk to any of the parties involved. And if they find that there is a violation, they try to get a reconciliation with the person who did the discrimination. And if that doesn't work out, then they can choose either whether it's the state or federal, choose to pursue their own litigation against the offender. So this is something that even if you're working with someone who's experienced discrimination, they don't feel comfortable suing the offender themselves, they can still file a complaint and make sure that person is getting investigated. I think another helpful thing to know is that there are fair housing testers out there, to where if you're working with folks and you're hearing, about discrimination from a particular landlord or mortgage lender, there's organizations like Housing Opportunities May Equal that'll do fair housing testing, and kind of like a secret shopper, they'll do things like call and say like, hey, I have a voucher, will you rent to me? And if they do that repeatedly and hear no, then they can use that to make a fair housing claim based on that testing. So it's a way of getting after the offender without the person who's been violated against really needing to put themselves out there and up to scrutiny. I know a lot of people fear retaliation, but one, retaliation for someone who's making a fair housing complaint is itself a separate fair housing violation. And two, there's a way to do this that is a bit more protective of the person who's making the complaint. So I can, and to the question of, can you say more how criminal backgrounds may violate the federal fair housing law? So I think it's helpful to look at what discrimination here means. And that is, the less favorable treatment of a person or group based on certain characteristics. And there's different types of discrimination, or it can look different ways. I think the one that people are most familiar with is intentional discrimination, purposely treating someone less favorably, someone making racist comments, that's clearly discrimination. But for the criminal background checks, that gets to what we call disparate impact, where you have a policy that seems neutral, it's not calling out, a particular protected class, but it negatively affects members of a protected class more than others. And this is where statistics come in with the criminal background checks. So say you have a landlord that says, I will not rent to anyone who has a criminal record. Well, particularly here in Virginia, we know the racist history of people who have criminal records, particularly certain types of drug offenses or, misdemeanor crimes or even, felonies. I think it's either 1 in 4 or 1 in 5 Black Virginians have a criminal record. And so you can see how this would disproportionately affect Black people who are, protected class based on race and color.
Yeah.
So,
oh, go ahead.
Go ahead, Christie.
I was just going to add a little bit more to the discussion of the criminal background check requirement, because as Laura says, it is, and there are memos, guidance from the Obama administration, still good guidance on this, that talk about the statistics nationally. Laura mentioned the statistics here in Virginia, which support a disparate impact claim against a landlord who has some type of blanket policy saying that we're not going to rent to people who have a felony conviction. We're not going to rent to people who have a misdemeanor conviction in the past 20 years. In addition to just looking for those blanket statements, if the landlord doesn't have any way, even with a less broad statement, right, a less broad category, say perhaps he says we're not going to rent to anybody with a felony conviction in the past 10 years, right, instead of forever and ever and ever. If that landlord doesn't have a way for a tenant to challenge that and to put on evidence and provide evidence of mitigating circumstances and evidence of rehabilitation, that can also be a violation of the Fair Housing Act, because it's going to have the same disparate impact. And we know that that analysis is something that has been certainly supported by the memos I mentioned earlier that came out of HUD in the, I don't know, what do we call that, the aughts, but also some case law across the country.
I thought to say that a landlord could not have any sort of criminal background requirement, but it just has to be specific to get at like what they're really trying to do. So, you know, it's fair if a landlord has a policy saying that, you know, I will not rent to someone who's had, you know, has been committed a sexual offense within the past 7 years. Like that's tailoring at like, you know, protecting the health and safety of the other residents, but you're not doing it in a way that's disproportionately affecting people of color. So as a question,
Yes.
would the landlord have to be qualified to accept vouchers or trained by a housing authority about how it works? Is that a choice for the landlord to opt in to accept vouchers?
So that question is not one that has a very clear black and white answer. What I can say is a landlord can't deny somebody just solely because they have a voucher that they're using for their rent. The landlord does not have to go through any special training to participate in the Section 8 Housing Choice Voucher Program. However, the landlord's rental unit, the unit that's going to be paid for with the voucher, does have to pass an inspection and meet something called the housing quality standards, which were set out by HUD. And if you look into those housing quality standards, you'll find that both on the housing provider side and on the tenant advocate side, people have been calling for reforms to them for a long time. Some of them are just outdated. And I think on the tenant side, that's where the reform request comes from. On the landlord side, what we're hearing and have been for a long time is that the inspections done by housing authorities and other voucher administrators simply take too long. And so there's actually, and I don't want to call it an opt-out provision, but a clause in Virginia's fair housing law regarding source of funds protection that says if the unit has not been approved, has not passed inspection and been improved within 15 days of, and I want to say it's within 15 days of when the application for tenancy is accepted, then the landlord can say, I can't hold this unit anymore. I'm sorry, I can't rent this to you because of this delay, without opening themselves up to liability under the Fair Housing Act. Nancy says, many landlords use third-party background checkers. Yes, they do. The potential landlord will not disclose any third party, and the third-party company says to get the credit report. So how do you challenge disparate impact under these circumstances? Okay. So the question there is, people are not getting what we would call adverse action letters from the landlord saying, this is why we denied you. Usually because, as Nancy points out, they don't know. They don't know why they're getting this thumbs down. And it is literally a thumbs down from the third-party tenant screening company just saying, don't rent to that person. And for those of you who haven't heard, for example, my friend Eric Dunn at the National Housing Law Project talk about this topic, and he is the national expert. And I urge you, if you ever get a chance to listen to Eric talk about tenant screening issues, don't miss it. And what he taught me is that there is essentially a menu. So when a landlord signs up for this third-party tenant screening service, there's a menu, and it's a list of things. What are the things that you want us to disqualify someone for? Is it, it can be as little as having an eviction case filed against them. It can be as big as embezzling money, millions of dollars, right? So it wouldn't be that specific, but it can be as big as, 3 felony convictions or whatever. But let's say a landlord says, yes, I want you to deny somebody for all of those reasons. And they get the decision from the third party screening company back with the thumbs down. They don't know if it's a thumbs down because the tenant once got sued for an eviction and it was dismissed, or because the tenant was convicted of embezzlement, right? So it is really hard to challenge these things without that information.
But on that point, um,
Yes.
so Eric Dove with the National Housing Law Project is, I believe, still in the middle of litigation. They had a trial early this year, suing one of these third-party tenant screening companies on a few different things. Like one, the underlying question is, does the Fair Housing Act apply to these third-party tenant screening companies? And I believe there's, motions on that to say yes, they are. And two, going through the facts to figure out what the final judgment is. So that one's still in limbo. But at least here in Virginia, there is a law that passed during the pandemic that says that you cannot refuse to rent someone because they have an eviction during the COVID state of emergency in Virginia. So basically trying to prohibit landlords from denying tenants simply because they fell behind on rent during the public health emergency. So this opens up a pathway for someone to request to get an adverse report. It's a very small one of a time, unfortunately. So if you're working with someone, they need to be on top of it, because the landlord basically, you have like very few days once you've been denied to request that report of why you were denied, and then to have some sort of challenge against it. But that's the only way in Virginia that I know of right now, that if you have someone denied, to figure out why, an actual like statutory procedure to do that. Even though the intent is to prohibit landlords from denying applicants because of the public health emergency, it could open up to find out what are the other reasons that that tenant may have been denied. It could be based on that. It could also just be based on, bad credit scores. And for those who don't know, the whole credit system has a lot of racist bases and assumptions built into it that harm Black people. So that's one way to get at it. And I think as far as figuring out like a disparate impact claim on those, I would say stay tuned to see how the National Housing Law Project's litigation, because if that goes well, I think it could open up whole new other enforcement mechanism to get after these tenant screening companies that really are discriminatory.
And even if it doesn't go well, and we certainly hope it does, at some point, the Poverty Law Center would be really interested in bringing some legislation to try to either require that all landlords provide adverse action notices promptly to tenants with details. Or one of the things that we worked on in the past was a piece of, and worked on with Eric Dunn's help, was a piece of legislation that would have allowed tenants to produce their own tenant report, and then use that report for a whole bunch of different landlords. That way the tenant would know from the get-go what is on the report and could challenge anything that was inaccurate before providing that report to the landlords. And it also helps tenants avoid paying multiple application fees. So we are hoping down the road a bit that there will be a warmer reception for that type of legislation in the legislature. So I want to be mindful that we have about 2 minutes left, but we have another question. If the fair housing law is good and public awareness is lacking, what is the most important message you would share with people? I would say educate yourself, take the time, it doesn't take long. VPLC is putting out tweets. Is that what we're doing, Laura?
Social media posts.
We're very tech savvy. So we have information on our website and social media. Housing Opportunities Made Equal has a lot of information, but basically take a few minutes and learn the basics of the Fair Housing Act.
I would say too that even if, because some people, like, it's hard to distinguish of like whether this person is just being unfair to you or if it's actual discrimination. And even if you're not sure, it's worth reaching out to an organization like Housing Opportunities Made Equal on how to go about making a complaint. and to investigate further, because the chances are if you've been discriminated against, there's someone else who's been discriminated against from the same person. And to stop bad actors, we need people to report instances of discrimination.
Exactly. So yeah, in a nutshell, trust your gut and make the call if you feel that you've been discriminated against in your efforts to access housing. Great. You guys this has been a really great conversation. Is there anything else that we can, yes, we have one question. Looks like Mr. Marshall, and I can't read the last part of your name, Marshall Washington, I'm guessing?
That is correct.
Okay.
If I'm not mistaken, the law says that if a tenant is in arrears and that arrears is paid and caught up, that the property manager or the property has to allow the tenant to maintain that lease at least through the end of the lease. Some of our tenants are getting a letter that says we will accept your payment, but we retain the right to move forward with the eviction.
Yeah.
And I'm just thinking about the legality of that.
So that, it's complicated because that's called a reservation notice. And back in the day, it was very common for landlords to issue those notices and say, yeah, you paid, but we're still going to evict you for paying late. They really can't do that anymore because we have something called the extended right of redemption. And that says that if a tenant pays everything they owe the landlord before the sheriff, 48 hours before the sheriff comes, so even after they get taken to court and get a judgment against them, the landlord has to allow them to stay. Now, there is an exception to that. If a tenant is renting from a smaller landlord and that landlord has given them written notice that they only allow one extended redemption per lease term, then the tenant could, if they've already used that extended right of redemption or right of redemption, they could, depending on when they made the payment, be evicted the following time.
I think the thing that gets people caught up a lot is, in order to exercise your right of redemption, you have to pay everything you owe the landlord, which, if you've gone through the court process, could include court fees and attorney's fees if there's something in that lease that says that the tenant has to pay that. So a partial payment is not going to stop the eviction. In that instance, if the tenant isn't able to get together all the money to pay everything they owe, it's better for that tenant to take what money they have for their next housing situation rather than sinking money into something and getting evicted anyways. But it's really that tenant's individual situation. One of the attempts last year to clarify that law is to make clear that partial payment won't count, but I think it still is confusing people because of how those notices are worded.
And that's really
smaller landlord is defined as fewer than 5 or 5 or fewer. Am I mistaken?
It's usually it's 4 or fewer.
4 or fewer.
Yes, so fewer than 5. I just want to follow up and add to what Laura just said. So one thing to keep in mind is that if there's an eviction case filed, that could follow that person and hurt that person's chances of getting the housing of their choice in the future. And so if a tenant can't pay the full amount and decides to move out and is able to find something more affordable, then the worst thing that's going to happen to them is that they're going to get a judgment against them for the money they owe. What the landlord should do in that case, if the tenant has moved out but still owes, let's say, $1,000, the landlord would file a different kind of case, so it wouldn't be an eviction case, and the tenant would not get an eviction filing showing up. It would just be a judgment under what we call a warrant in debt. Now, the problem with that is that still is a potentially collectible judgment. Their wages can be garnished, etc., but it doesn't have quite the same impact on their future housing. All right, are there any other questions? Anything anybody wants to share before we say goodbye and have a wonderful day?
I just want to shout out that we have the link in the chat for Housing Opportunities Made Equal. For if you have someone who thinks they've been discriminated against, they can help them file a complaint and determine whether there's a violation of the Fair Housing Act.
And please feel free to be ambassadors on this law and go out and talk about the fact that it exists and talk about the fact that there's lots of good information, especially on the Housing Opportunities Made Equal website, but also on the, there's some information that we're putting out. We are, you know, we love having these coffee chats, and we hope that you guys keep talking about the issues when you go out into the community and to your jobs and to your families and to, you know, cookouts and whatnot.
Christie, can I say one thing?
Of course.
Okay, I just wanted to, I don't know if you said this at the very beginning, but the affirmatively furthering fair housing new HUD rules is has an extended period of review. It's I think through April 20 something. And it's a long document, but it's kind of worth looking at that. That's going to be the new requirements for how people frame their goals and how they frame their actions, how jurisdictions frame their goals and actions about fair housing, and how they report on what they've done. So it's kind of a big deal. I think it's pretty good. Urge people to read it and take a look at it.
Thank you. Yeah.
Yeah, I put a link to
parts.
I put a link to the news release about the new affirmatively fair housing rule in the chat.
Great. And thank you, Mary, for bringing that up. And in fact, Housing Opportunities Made Equal and Poverty Law Center, and I think Legal Aid Justice Center, maybe a few other groups did submit comments to HUD on that. So yes, it could be a game changer. And we're looking forward to seeing the final rule. And we'll probably do another training on that.
Good.
And we hope you'll join us for our next coffee chat on April 20th to get a recap of this year's legislative session. This Wednesday, I think or tomorrow, they go back in for the reconvene session. Hopefully we'll have a bit more update on what's happening with the budget at that point, but stay tuned and join us next week.
Thanks for joining us this morning, everybody.
Thank you.